Hello aspirants, welcome back to India for IAS. This is Manjunath Mudho. In this video, we are going to study about Supreme Court Legal Services Committee. This topic falls under GS-2 Judiciary part. This topic falls under GS-2 Judiciary part. This topic is very important both for prelims and mains. It is important topic for both prelims and mains. UPSC has asked questions in prelims based on this topic. In this video, we are going to study about what is Supreme Court Legal Services Committee, what's its composition, what is its purpose, need for legal services in India, then Legal Services Authorities Act, NALSA and SALSA. So these are the topics that we are going to discuss in this video. Recently, Supreme Court Legal Services Committee was in news because Justice Gawai had been nominated as chairman of the Supreme Court Legal Services Committee. Now let us discuss in detail about Supreme Court Legal Services Committee. So its purpose is to provide free and competent legal service to weaker sections of society. To whom? Weaker sections of society. It formed under Section 3A of Legal Services Authorities Act 1987. So it was formed under Section 3 of Legal Services Authorities Act. It handles the cases that are falling under Supreme Court's jurisdiction. So it handles the cases that are falling under Supreme Court jurisdiction. It means it provides free and competent legal service to weaker sections of society for those cases which fall under the jurisdiction of Supreme Court. The constitution of this committee is done by NALSA. So NALSA is the authority which establishes Supreme Court Legal Services Committee. Chief Justice of India, that is CJI, is the authority who appoints the members and chairman of the committee. The CJI also appoints the secretary to the committee. So the CJI is the authority who appoints the members, chairman and secretary of the committee. Moving on to the composition of Supreme Court Legal Services Committee. So it has one chairman. The present chairman is Justice B.R. Gawai. So the present chairman is Justice B.I. Gawai and it has 9 members. These members and chairman are appointed as per the Rule 10 of NALSA. So we are going to study about NALSA in detail in the coming slides. Now let us discuss why there is a need for free legal aid services in India. So Article 21 of the Constitution talks about right to life and liberty. It talks about right to life and liberty. So without free legal aid, vast majority of the population, weaker sections, so they will be deprived of justice. If there is no justice, there is no liberty and there is no right to life. So free legal aid is inherent in Article 21 of the Constitution. Article 39, which was introduced through 42nd Constitutional Amendment Act, empowers the state to provide free legal aid to the weaker sections of society. So this article promotes justice on the basis of equal opportunity to all sections of society. Then the third point is Article 14. So Article 14 guarantees right to equality. It guarantees right to equality. Since in India, the legal services are unaffordable to the poor sections of society, so if the state does not provide free legal aid, then vast majority of the population are deprived of justice. Then there is no equality between rich and poor in accessing justice. So the Article 14 necessitates the provision of free legal aid to the weaker sections of society. Then the fourth point is Article 22 Clause 1. This article says that right to be informed right to be informed on the grounds of arrest. Right to be informed of the grounds of arrest. So without free legal aid, the poor section of society unable to know the grounds on which they have been arrested. So this is one of the reasons for lot of under trials in the Indian prisons. The fifth point is to prevent the denial of justice to any citizen due to economic or other disabilities. So due to economic or other disabilities. So no section of society or an individual should not be deprived of justice just because he cannot afford the judicial services. So one of the need for establishing free legal services in India is to prevent the denial of justice based on economic criteria. Then provision of free legal aid is one of the responsibility of the state. So as we have discussed earlier, as per Article 39A of the Constitution, the state should promote justice on equal basis. This responsibility of the state can be achieved through legislation, schemes, can be achieved through legislation, schemes, or any other means. Legislation and schemes or any other means. The prime objective of free legal aid service is to ensure that all the citizens have equal opportunities to secure justice irrespective of their economic status. Now briefly discuss about origins and background of the legal aid programs in India. So the legal aid programs in India was thought first in the year 1950s by judiciary, that is Supreme Court. So Supreme Court thought of providing free legal aid to the poor sections of society. Then in the year 1980s, a national level committee was formed under the chairmanship of P.N. Bhagavati. Under the chairmanship of Justice P.N. Bhagavati, the role of the committee is to monitor the legal aid activities all over India. So its role is to monitor the legal aid activities all over India. Now let us discuss about Legal Services Authorities Act 1987. So this is the main act which laid the foundation for legal aid programs in India. So the act enacted in the year 1987. So the act was enacted in the year 1987 and it laid the statutory foundation for free legal aid in India. It laid the statutory foundation for free legal aid in India and its objectives are to provide free and competent legal services to specific group, free and competent legal services to specific group in the society. The eligible groups for free legal aid services include women, children, SCST and EWS category people, transgenders, industrial workers. So transgenders, industrial workers, many others. So the details beneficiary of the free legal aid services are provided in the PDF handout. So please go to the handout. The Legal Services Authorities Act provides for the establishment of NALSA at the national level, SALSA at the state level, then District Legal Services Authority at the district level, and Taluk Legal Services at the Taluk level. So now we will discuss the National Legal Services Authorities Act. So it was constituted in the year 1995. It was constituted in the year 1995. So its role is to monitor and evaluate the legal aid program implementation in India. So its role is to monitor and evaluate the legal aid programs in India. So it develops policies for the availability of legal services. It also develops policies for the availability of legal services in India. Develop policies for the legal aid services in India. To provide legal aid and assistance on national scale, so the NALSA establishes nationwide network with NGOs and civil society, It also distributes funds to the NGOs and civil society, and also to the State Legal Services Authorities Act to implement the legal aid programs. Now let us discuss about State Legal Services Authorities. They are formed in each state. State legal authorities are established in each state and they are established to implement the policies of NALSA. They are established to implement the policies of NALSA. So coming to the functions of the State Legal Services Authorities. So they implement the NALSA policies. Implement the NALSA policies. They implement the NALSA policies. They provide free legal aid services. They provide free legal services. They provide free legal services. Then the third point is they conduct lok adalats. They conduct lok adalats. Coming to the composition of State Legal Services Authority, the head of the State Legal Services Authorities is Chief Justice of respective High Court. Chief Justice of respective High Court. And the executive chairman is Senior Judge of the High Court. The executive chairman is Senior Judge of the respective High Court. Coming to the patronage, the Chief Justice of respective High Court serves as the patron-in-chief for State Legal Services Authorities Act, and for NALSA it is the Chief Justice of India who is patron-in-chief. Chief Justice of India is the patron-in-chief for NALSA. Then we have District Legal Services Authorities. They are established in each districts. They are established in each district of the country. So the chairperson of the District Legal Services Authorities is District Judge of the respective district. Chairperson is District Judge of the respective district. And then at the Taluka level, we have Taluk Legal Services Committee. So the head of the Taluk Legal Services Committee is Senior Civil Judge. The head of the Taluka Legal Services Committee is Senior Civil Judge. Then the functions of the District Legal Services Authority and Taluka Legal Services Committees are to provide free legal aid to the weaker sections of society. To provide free legal aid to the weaker sections of society and to organize legal awareness camps. Legal awareness camps. So these are the functions of the DLSA and Taluka committees. So this is all about Supreme Court Legal Services Commission, its parent act, Legal Services Authorities Act 1987. Then at national level we have studied NALSA, at state level SALSA, and at district level DLSA, and at Taluka level Taluka Legal Services Committee. So we have provided one previous year prelims question. The UPSC has asked in the year 2020 one question based on Free Legal Services Authorities Act. So go through the statement of the question and comment your answer in the comment box. The PDF handout of this class is available in our Telegram and WhatsApp channel. In that handout, we have provided in detail about the eligible beneficiaries of the free legal aid services. Thank you for watching. See you in the next video.